come back in and Mr. Lewin can resume his cross-examination. All right, I received a copy of an email sent by Mr. Siegel. It was last night at 8:32 p.m. and it was addressed to Paul Kozlomek and John Lewin and the other participants in the trial legal counsel. And the email states, during the preparation of our summary relating to Louis Levin, who is the next witness, yes?
Yes, Your Honor.
We inadvertently omitted certain information he conveyed to us in August of 2024. An omission we only realized after Mr. Phillips was asked questions about the prop gun's whereabouts on Friday. Accordingly, we met with Mr. Levin today, who reiterated the following information that he conveyed previously. Mr. Levin was involved in the decision-making with for Rocky not to carry the prop gun after November 6th of 2021, because it did not serve its intended purpose of acting as a deterrent. Consequently, Mr. Levin took possession of the prop gun after November 6th of 2021 and subsequently contacted a co-writer/co-director on the DMB music video from which it was obtained in order to make arrangements to return it while in New York. In that regard, Mr. Levin met at the Roxy Hotel in New York with the co-writer/co-director and gave him the prop gun and accompanying accessories. Mr. Levin,
this is great for defense.
Provide you, the prosecutors, with the name and contact information for the co-writer/co-director, and also to meet with you tomorrow at 9:30. This is late discovery. Without casting any aspersions, I am not accepting the
Prosecution.
Can't come in.
Sorry.
Who was that? What was that noise?
I opened my laptop and the sound came out. Sorry.
Oh.
Why did it yell
I'm not
prosecution?
accepting that it was inadvertent. There is a summary.
So it can't come in,
by the
maybe.
defense to the prosecution as required by Penal Code Section 1054, and it lists a number of areas that Mr. Levin is going to be testifying about. There is no mention in the summary about him taking possession of the prop gun and what he did with it after. Now, there's a case called People versus Jackson. And that site is 15 Calat Court, 1197. In this case, the court completely precluded defense witnesses, a defense witness, because here, I'm going to quote from the case. Here, because the testimony was allegedly exculpatory, the trial court refused to believe defense counsel did not seriously consider calling the witness until moments before he did. Even if withholding the identity of the witness was not willful, lesser sanctions would not have been adequate. Immediate disclosure or contempt of counsel would have been insufficient because the people would not have had a meaningful opportunity to rebut or impeach the statement. Similarly, a continuance would have been inadequate because the declarant's whereabouts were unknown.
He's reading case law right now that would support his decision if he chooses to exclude testimony relating to this prop gun and or testimony of the recipient, the alleged recipient of this prop gun,
And thus,
because of late
her
discovery by the defense.
unavailability precluded the people from cross-examining her. The people would have been unduly prejudiced by admitting the testimony without an opportunity for cross-examination, and the integrity of the adversary process would have been compromised, as parties with little to lose would be encouraged to not comply with pre-trial discovery rules. The court did not abuse its discretion in precluding the testimony. And this is what the court in Jackson also ruled. Rather than comply with reciprocal discovery rules by giving the people the name of the witness and the proposed testimony, he chose to surprise the people with a statement at trial, admitting such potentially unreliable evidence, untested by cross-examination, would not only have prejudiced the people's case, but would have undermined the discovery process. So the situation we have is not quite like Jackson, but it approaches Jackson. I believe that under Jackson, I would have had the authority to preclude Mr.
Is he
Levin
going to
from
let it
giving
in?
any testimony about this recently discovered evidence, or this information that was recently turned over to the police about him taking possession of the prop gun and what he did with it. If I did that, however, the defense case would be prejudiced.
He's gonna let it in. He's gonna let Levin testify about it. Oh my God, we are getting the current whereabouts of the prop gun.
But then
Wow.
I'm also concerned about
Big win
prejudice
for
to the people,
defense.
because this came late in the game. So this is the way I thought it to be remedied, so that neither side is prejudiced and both sides can fully present their case. Before Mr. Levin takes the stand, I required that he agree
Interview.
to a complete interview by the prosecution, and I understand that happened.
Yes, after initially refusing to speak with us, he
All right,
spoke
so-
to us a few moments ago.
Already done
I
it.
also required that the person who took possession of the gun, the director in New York, that he be interviewed on tape by the people, and if Mr. Levin testifies to anything that is inconsistent with any prior statements he made to this person in New York, that the tape can be played to impeach Mr. Levin's testimony, if there is any. So that's the way we're going to remedy to ensure both sides are treated fairly, neither side is prejudiced, both sides get to fully present their case. Now, I understand, Mr. Lewin, you interviewed Mr. Levin for a period of time, and you said some additional information has come forward that you did not have on Friday, which relates to the witness on the stand now?
Yeah, yes, Your Honor, both from, it's going to be important, I don't want to disclose it, but I can tell you that based on what we're being told now, there are going to be questions I'm going to have to ask of the current witness on the stand. With that in mind, I'm asking the court for an additional...
Then 90 minutes.
I understand the court is given 90, I'm going to ask for...
Why does he need to ask 12E about this circumstance with Lou Levin and the co-writer, co-director of the video in New York? He's just trying to get more than his 90 minutes.
30 minutes, I promised the court I would finish during that time.
All right,
Right,
is this
chicken.
information that you did not have on Friday while you were cross-examining the witness?
Yes, that is correct.
So when did you discover this additional information?
Well, I discovered it in speaking to the individual, just so it's clear, when they turned over the information last night, they still did not identify who the person was. When the court ordered that it be turned over this morning, they didn't immediately turn it over. I found out who the person was sometime around 8:30 this morning, and we were able to call him, and we interviewed that individual.
Did his identity and contact information come from someone on the defense?
Yes, so eventually they supplied it. I sent a very nasty email explaining to them that I wasn't asking for it, the judge ordered it, and they better turn it over. And they finally turned it over.
All right.
Then he became sworn. We then interviewed Mr. Levin, and there are, as a result of those two interviews, there are some issues that I now
All right, okay. I had said Friday, 90 minutes, and that was in stone, 90 minutes. However, because of the new information,
95.
You'll get the additional 30 minutes. So it's a total of 2 hours and not 121 minutes, 120 minutes.
Right, although you did say, Your Honor, you would let my co-counsel have the clock.
Yeah, I don't care who times it, but
You were a little quick on blood here, Your Honor.
so it's going to be 2 hours. hours from the time he takes the stand.
Yes.
I just want to remind everybody at council table that CCP 177 still applies. I'm not going to tolerate any speaking objections, arguing with a witness, arguing with each other, snide comments made to each other, and arguing with a decision of mine. That still remains in full force and effect. All right, let's bring in the jury.
Your Honor, there's one last thing to, that we need to put on the
Oh my
record.
God, John.
One, regarding the court's last comment, we just want to make sure we have to get it grounds because we cannot respond to these grounds. The court's ordered it, so I would
Listen,
will
the
not
defense is well aware.
Okay.
If there's an objection, the legal basis has to be, it has to be stated.
The second issue, Your Honor, is the court said the court did not want to, quote, cast aspersions on either side. The court has found that this was not inadvertent.
That's right, and nothing more need be said about it. I did not find it was inadvertent, that's why I came up with the remedy I did. I don't want to talk any more about it than I already have. Let's bring in the jury.
I love it. Bring in the jury. Bring in the jury. Holy moly. I mean,
Oh, and 12.
oh, and bring in 12E.